157 CRPC procedure where cognizable offences suspected. So if from information received or otherwise an officer in charge of police station has reason to suspect the commission of offences which he is empowered under section 156 to investigate, and he shall forthwith send a report of the same to a magistrate empowered to take a cognizance of such offences upon a police report, and shall proceed in person or shall depute one of his subordinate officer not being a below such a rank as the provincial government may by general or special order or prescribe in this behalf to proceed to the spot or to investigate the fact and circumstances of the case, if necessary to take measures for the discovery and arrest of the offender, provided as follows. Where a local investigation dispense with. So when any information as to the commission of any such offences is given against any person by name, and the case is not of a serious nature, the officer in charge of police station need not proceed in person or depute a subordinate officer to make an investigation on the spot. Where police officer in charge sees no sufficient ground for investigation, if it appears to the officer in charge of a police station that there is no sufficient ground for entering on an investigation, and he shall not investigate the case. In each of the cases mentioned class A and B of the provision to subsection, the officer in charge of police station shall state in his said report his reasons for not fully complying with the requirement of that section. In the case mentioned class, such officer shall also forth notify to the informant, if any such a manner as may be prescribed by the provincial government, the fact that he shall not investigate case or cause to be investigated. इन में असां ॿ शयूं टे या पढ़ियूंसीं त जेकॾहिं कंहिं केस में कॉग्निजेंस में असांखे शक थो थिए त जेको हद जो इंचार्ज आहे पुलिस ऑफिसर एसएचओ उहो वरी जेको आहे मजिस्ट्रेट खे चवंदो त तव्हां हिन जी कॉग्निजेंस वठो, तव्हां असांखे ॾियो त असां वरी हिन ते जेको आहे इन्वेस्टिगेट कयूं। ऐं 156 में पढ़ी आयासीं त पुलिस ऑफिसर सां चवंदो आहे इन्वेस्टिगेशन कंदो आहे। इन्वेस्टिगेशन थींदी तॾहिं आहे जॾहिं माना कंहिं क़िस्म जो प्रूफ थिए, कलेक्शन्स ऑफ एविडेंस पैदा थियनि से जीअं थियनि माण्हूअ खे। उन खां पोइ 158 में रिपोर्ट्स अंडर सेक्शन 157 हाउ सबमिटेड, चए थो एवरी रिपोर्ट सेंट टू अ मैजिस्ट्रेट अंडर सेक्शन 157 shall, if the provincial government so direct, be submitted through such a superior officer of police as the provincial government by general or special order appoint in that behalf. Such a superior officer may give such an instruction to the officer in charge of the police station as he thinks fit, and shall, after recording such an instruction on such a report, transmit the same without delay to the magistrate. Report पेश थींदी आहे, चए थो एवरी रिपोर्ट, हाणे रिपोर्ट केरु ॾींदो, पुलिस ॾींदी कंहिं मैजिस्ट्रेट खे, त उहा जेको आहे प्रोविंशियल जेको असांजो प्रोविंशियल गवर्नमेंट जेको आहे त यानी कि पुलिस ऑफिसर या प्रोविंशियल गवर्नमेंट जेको असांजी अपॉइंटमेंट कंदी आहे। उन खां पोइ 159 में आहे पावर टू होल्ड इन्वेस्टिगेशन और प्रीलिमिनरी इंक्वायरी। 159 में चए थो मैजिस्ट्रेट ऑन रिसीविंग सच अ रिपोर्ट, चए थो जॾहिं उहा मैजिस्ट्रेट रिपोर्ट रिसीव कई, मे डायरेक्ट एन इन्वेस्टिगेशन और इफ ही थिंक्स फिट एट वंस प्रोसीड or depute any magistrate subordinate to him to proceed to hold a preliminary inquiry into, or otherwise to dispose of the case in manner provided in this code. उन खां पोइ जेको आहे 160 में असांजो सेक्शन आहे पुलिस ऑफिसर पावर टू रिक्वायर द अटेंडेंस ऑफ विटनेसिस। चए थो एनी पुलिस ऑफिसर making an investigation under this chapter may by order in writing, require the attendance before himself of any person being within the limits of his own or any adjoining station who, from the information given or otherwise appears to be acquainted with the circumstance of the case. Such a period shall attend as so required. 161 असांजी examinations of witnesses by police are. So any police officer making an investigation under this chapter or any police officer not below such a rank, the provincial government may, by general or special order, prescribe in this behalf, acting on the requisition of such officer, and may explain orally any person supposed to be acquainted with the facts and the circumstances of the case, provided that the statement of women against women offence under section 336B या 354 section 364A section 374 जेको असांजी आहे 509 पाकिस्तान जी 1960 is alleged to have been committed or attempted shall by any investigation officer in the presence of female police officer or female family member or other person of her choice. Such a person shall be bound to answer all questions relating to such a case put to him by such officer other than question the answer to which would have a tendency to expose him to a criminal charge or to a penalty of forfeiture. The police officer may reduce into writing any statement made to him in the course of an examination under this section. If he does so, he shall make a separate record of the statement of each of such a person whose statement he records. उन खां पोइ असांजी जेको सेक्शन आहे 161 लीगल रिप्रेज़ेंटेशन्स ऑफ द विक्टम्स ऑफ रेप जेको आहे 61A चए थो वेन एन ऑफेंस इज अंडर सेक्शन अंडर सेक्शन 354A सेक्शन 376 सेक्शन 377 या जेको 377B ऑफ पाकिस्तान पीनल कोड 1960 हैज़ बीन कमिटेड आर अटेम्प्ट टू बी committed, the police officer, after the recording information under section 154, shall inform the victim against whom such offences have been committed or attempt to be committed of his or her right to legal representation. If the victims require free legal aid, the police officer shall provide the list of lawyers maintained by the provincial bar council for his purpose. ऐं उन खां पोइ चए थो 162 statement to police not to be signed, use of statements in evidences. So no statement by any person to a police officer in the course of an investigation under this chapter shall, if reduced into writing, be signed by the person making it, nor shall any such statement or any record thereof, whether in a police diary or otherwise any part of such a statement or record be used for any purpose, save is here and after provided if any inquiry trial in respect of any offences under investigation at the time and such a statement was made, provided that when any witness is called for the prosecution such inquiry trial whose statement has been reduced into writing as aforesaid, the court shall on the request of the accused refer to such a writing, direct that such accused be furnished with a copy thereof, in order that any part of such a statement duly served may be used contrary such a statement in the manner provided by section of 45 of Evidence Act 1972. When any part of such a statement so used, any part there may also be used in the re-examination of such a witness. But for the purpose of only of explaining any matter referred to in the cross-examination. Provide further that if the court is of opinion that any part of any such a statement is not relevant to the subject matter of the inquiry trial, that it is a disclosure to the accused is not essential to in the interest of justice, expedient in public interest, shall record such opinion but not reason thereof exclude such a part from the copy of the statement furnished to the accused. Nothing in this section will be deemed to apply to any statement falling with the provision of section 3 class 1 of the Evidence Act 1972 to affect the provision of section 27 of that Act.